necessarily the final set, but I think this incorporates a lot of your concerns and issues. So let's just go through, the easiest way to do this again is just going through these instructions and let me know if you have an objection. And then we'll go back and you can certainly make a record as to instructions that are not included in these instructions. These instructions also have some blanks to fill in and cross-reference instruction numbers. I will do that once we finish. These are not necessarily in the order in which they're going to be given. Okay? So starting with the cover page, any objection?
No.
No. Members of the jury, any objection?
No.
I added that last sentence at your request.
Thank you.
I didn't like the word surrender. I'm not going to be confiscating their phones. And so I said, turn off your phones rather than surrender, which is one of the language in the stock instructions. Not sure if it's appropriate to have them surrender their cell phones, unless you think that's appropriate.
I understand the court's concerns about surrendering. Maybe
I used the word turn off.
I'm just trying to think of a way we can put
And not access?
yes,
Your order to turn
or
off.
not bring in the devices even into the deliberation room. Maybe they can leave them in their cars.
Well, during the breaks, I'm sure they want to check their emails and make sure everything is okay. And I don't want to prohibit them from doing that.
Well, they can go out to their cars.
Yes, 2 blocks away
Yeah, exercise is important.
in 106-degree weather.
It's good for the skin.
The message is clearly sent that they can't use their phones
I think so too.
to gain information about the case.
I think so too. All right, so that's the way we're going to have it. Next instruction. There's a page 2 of 2. I'm assuming you have no objection to page 2 of 2.
Correct.
No.
Next instruction, and I just mimicked the defense's language. The charges against Mr. Eastman are not evidence, and then I broke them up into actual counts.
Just that there's some weird spacing on count 1.
I tried to fix that, and it didn't. Let me try to reformat this. Give me a second.
So I think the rest of the counts are single spacing, and that one looks to be double spacing, line spacing.
Also, page 2 of 2. This is page 2 of 2.
Oh, it does say. See, there's
A between complaint and information is also capitalized.
Sheriff, can you fix that? Thank you. All right, we'll fix the spacing. Any objection to the instruction, the substance of the instruction?
No.
You know, just as it, I don't know if the court heard me, or the second paragraph, the complaint and information, the A and is capitalized.
We'll change the A in and to lowercase. Thank you. Next instruction is the theory of defense. Any objection, Mr. Wren?
No.
I've never had that happen. Sorry. I've never had a DA not object to the theory of defense.
I think it's exactly what the law allows for. It's
Thank you.
brief and it doesn't restate the law, but it truly is a theory. Next is news coverage.
No objection.
No objection.
Next is presumption of innocence.
No objection.
No objection.
Next is, in this case, a separate offense is charged against Mr. Eastman.
No objection.
No objection.
Next is general credibility.
No objection.
Next is every defendant has a constitutional right not to testify.
No objection.
No objection.
Next is the number of witnesses.
No objection.
No objection.
Next is expert testimony, notwithstanding your objections yesterday. Ms. Devereaux, any other objections?
No.
Mr. Wren?
No.
Next is the law on direct and circumstantial evidence without the bracketed examples.
No objection.
No objection.
Next is the limited purpose / 404B evidence instruction, notwithstanding numerous previous objections. Any other objections?
No.
Thank you. Carefully worded that question.
Appreciate that.
Next is the instruction that was objected to by the prosecution dealing with the 404B statement made in the recorded interview with law enforcement and Mr. Eastman, notwithstanding any other objection. Mr. Wren? Any previous objection? Any other objection? I didn't change it since yesterday.
No. No additional objection.
Thank you. Next is how a felony conviction affects the credibility of a witness. And I took out the paragraph involving Mr. Eastman since he did not testify.
No objection.
No objection.
The next is the 608 instruction regarding reputation for truthfulness.
No objection.
This is stock. Thank you. Next is the judicial notice instruction.
No objection.
No objection.
Next is stipulated fact.
No objection.
No objection.
And I probably should change that to singular instead of plural.
And I think we need to add the word by, Masha.
Oh, yes, thank you. And I'm going to just put fact instead of facts.
Mm-hmm.
Is that okay with you?
Yes.
Yes.
So you think we should read on the second sentence, you may regard those facts, just change that to, you may regard this fact as proven?
Yes. And I think also the facts at the end of the third sentence.
So
Yes.
Did you say it's going to read, you may regard this fact?
I'll read you the entire instruction, which is not very long, the way I've now changed it. The parties have agreed as to the existence of a certain fact. You may regard this fact as proven. Specifically, the parties have stipulated to the following fact. The knife photographed in People's Exhibit 219 was sent to the Colorado Bureau of Investigations. In parens, I have CBI, end parens, and analyzed by Masha and her last name.
Yes.
I don't think it matters. But I'm not sure that there's a C in her last name.
How do you spell, tell me again how you spell her last name?
Ms. Morris is saying no C as well.
No C. So it's spelled Signaevsky.
Yes.
Thank you. Next is the instruction on actus reus and mens rea.
No objection.
No objection.
The next instruction, and we'll talk about, I do believe this is necessary even with the complicity instruction. So with regard to that objection, I'm overruling that objection, but any objection to the elemental as it relates to first-degree murder involving Scott Sessions.
Nothing further, just renew my previous objections.
Thank you. Mr. Wren?
Objection.
Next is somewhat of an identical, elemental, different dates, and of course, different victim for first-degree murder, elemental.
No objection.
No objection.
Next is the elemental as it relates to Scott Sessions with tampering with a deceased human body.
No objection.
No objection. Actually, sorry, the paragraphs are not in line with each other. The last two sentences.
Okay, Sheriff, can you take care of that? Thank you. For the record, Shira is my law clerk. So when somebody's looking at this transcript, they know who Shira is.
I heard a voice and I thought,
Okay, next is the elemental for tampering with a deceased human body as it relates to Miss Frank.
no objection.
No objection.
Next is the elemental for tampering with physical evidence as it relates to Mr. Sessions.
No objection.
No objection.
The next is the elemental as it relates to Miss Frank for tampering with physical evidence.
No objection.
No objection.
So I got an email from Miss Devereaux at 10:16 last night, and so I incorporated this for discussion this morning, but she wanted me to give instruction E11 pursuant to comment 1 of the stock instructions. And her email indicated we would be requesting a unanimity instruction for counts 2 and 3. I'm not sure if that's correct. For counts 2 and 3?
I think it's probably just for,
Because count 2 is first degree murder.
yeah, no, that wasn't, I think why I was saying 2 and 3 was because of how the court had, in its previous email to us, laid it out.
Yeah.
So just to be clear, it's just for the tampering, the 4 tampering charges.
For counts 3 through 6.
Yes.
Okay.
Sorry for that confusion.
No, that's fine. So, in order to convict the defendant of the, so I've changed it a little. This is what it reads. In order to convict the defendant of the crimes of tampering with a deceased human body and tampering with physical evidence, you must either unanimously agree that the defendant committed the same act or acts, or he committed all of the acts alleged. Mr. Wren, what's your position?
No objection.
Okay. Next is the definitions. Mr. Wren requested last night, pursuant to a 2022 case, which I believe is accurate, simply the definition of the term about to be instituted, which his suggested languages includes an act that the actor believes could trigger an official proceeding in the future.
My only objection to that is I read the Newton case, and my interpretation was that the belief had to be at the time of the act. And that's not necessarily clear with Mr. Wren's definition.
What is your suggested language?
I would suggest includes an act at the time which the actor believed, or the act, at the time.
So you want the language to read, quote, about to be instituted, end quote, includes an act at the time that the actor believes could trigger an official proceeding in the future?
Yes, please.
Mr. Wren, what's your thought about that?
I don't think that the language that I proposed misleads anybody as to the timing. I think it's an accurate reflection of the current state of the law, so I'm asking that the court give the definition as I proposed it.
You think that it's an incorrect statement to say at the time?
At the time that he is moving or concealing the evidence? Is that what we're trying to convey?
Yes.
The question is, when it says,
No, I don't believe it's an inconsistent or an inaccurate statement of the law.
so just to be clear, it may be implicit, but I'm just gonna spell it out for them, so I'm gonna just keep that language. It's gonna read, about to be instituted includes an act at the time that the actor believes could trigger an official proceeding in the future.
Yes, please.
Okay.
Thank you.
And I just defined those 4 terms alphabetically, so I just kind of changed the order.
That's fine. No objection to that.
Thank you. Next is the complicity instruction. And I made it specific to the prosecutor's theory or alternate theory of complicity only as it relates to the charge of murder in the first degree as it relates to Heather Frank as either principal or compliciter.
My only concern with that is when I read that, that seems unclear in terms of whether Miss Frank was a compliciter or is she the victim there?
How would you like to word it? To me, it's not unclear. It mimics the stock language, but
I think it should be related to the death of Miss Frank.
I'm not going to use the word death. I'm going to use the word murder in the first degree. That's the crime.
How about Miss Frank as a victim then? Or a specific, or a specific count? My concern is that it could be construed that Miss Frank and Mr. Eastman conspired together.
How about this? The prosecution alleges that Mr. Eastman is guilty of the crime of murder in the first degree as it relates to victim Heather Frank as a principal or as a compliciter.
That's still unclear to me, because it could be that Miss Frank was, the language that's concerning to me is Heather Frank as a principal or as a compliciter. And I think that because of that order, because of the unique facts in this case, it could be construed that Miss Frank was the principal or compliciter.
So why don't we just do this? Prosecution alleges that Mr. Eastman is guilty of the crime of murder in the first degree as alleged in count 2.
That's fine.
Okay. So I put of the complaint and information.
I'm sorry, sir?
Should I just say as alleged in count 2 in the complaint and information?
Yes, please. Can you say it as to count 2 only?
Yes. Let me just reread that, make sure we're all on the same page. So the first sentence will read, the prosecution alleges that Mr. Eastman is guilty of the crime of murder in the first degree as alleged in count 2 only of the complaint and information as a principal or as a compliciter.
Yes.
Okay, Mr. Wright, you okay with that?
Yes.
And then we have the next instruction, which talks about the elements for compliciter and then the elements for first degree murder. The only thing that I want to have a discussion about is element number 4 of complicity. And when I read, give me 1 second, please.
And Judge, sorry, while we're talking about the theory of complicity, we would also request the unanimity instruction apply to that as well.
Say that again?
We would also request that the unanimity instruction also apply to the complicity count.
Well, it's not a count, it's a theory.
Well, right, so either they all believe that he did it, or they believe he was complicit.
Okay. What are your thoughts about that, Mr. Wren? I think the concern for the defense is that, for example, 6 people find that he was a complicit, or 6 people find that he was the principal.
I think the law allows that. I don't believe that that issue triggers a unanimity problem.
Do you have any case law to support your position? Because I tend to agree with the prosecution that that's the jury who gets to decide.
I could have one moment.
Yes. The other point that I wanted to make is on instruction J:03 for complicity. There's 2 options for element 4. One is the defendant was aware of all of the elements of that crime, or the defendant was aware of element numbers such and such as defined at the end of this instruction. And the difference is set forth in People versus Childress. It's a Supreme Court case, 2015 CO 65M. In that case, what they say is that under Colorado law, complicity liability demands that the defendant must have been aware of either some or all of the elements of the principles underlying crime, depending on the crime. More specifically, the defendant must have been aware of those elements of the offense describing the prohibited act itself and the circumstances surrounding its commission, including the mental state. But the defendant need not be aware of, quote, any element requiring that such act have a particular effect or cause a particular result. Therefore, if one of the elements of the underlying crime involves an act having a particular effect or causing a particular result, the court needs to give that second option in bracket number 4. Here, one of the elements of murder is caused the death of Heather Frank. So I don't believe that the complicitor prosecution needs to prove as a complicitor that element, because this is something causing the death. I think they need to be able to prove elements 1 through 5 inclusive, not 6. So I guess the discussion I want to have with you is whether element 4 should read, Mr. Eastman was aware of all of the elements, or as recommended by the annotation based on the Childress case, Mr. Eastman was aware of elements 1 through 5 inclusive as defined at the end of this instruction. I think it's the latter.
Can I have that case one more time, please?
Yeah, the Childress case is found at 2015 CO 65, and it was a modified opinion by the Supreme Court.
And it's comment 2 the court's referring to?
Comment,
Of Colgy?
yes. And if you want to provide me with case law on the unanimity as to complicitor versus principal, I would like to be able to read that.
I could have a moment for both those issues. I just want to state for the record, because the prosecution is seeking 2 alternate theories of liability with respect to the same crime, namely murder in the first degree involving Heather Frank, the court is making a determination as a matter of law that both
requested options or theories of liability to the jury is supported by the evidence in this case. And so that's why I believe it's appropriate to give that instruction.
You believe it is appropriate to give
Both the complicity instruction based on the prosecutors, the evidence supports two possible theories of murder in the first degree involving your client, one for principal and one for complicitor.
So what the court's saying in terms of the complicitor instruction is that for the first paragraph 4.
So I think under the Childress case, I don't think that the prosecution needs to prove element number 6 of murder in the first degree causing that result as a complicitor. I think they have to be able to prove elements 1 through 5.
I'm just reading Childress, and I agree that that's what it seems to say.
I think that that's what comment 2, I mean, I disagree with it for the record. I think that that should be something that the government has to prove beyond reasonable doubt considering the type of crime this is. But I do agree with the court that that's what comment 2 seems to suggest, and also the Childress case.
So I'm gonna, element number 4 of the instruction is going to read, Mr. Eastman was aware of elements 1 through 5 inclusive as defined at the end of this instruction.
Yes.
Okay. And I'm going to move on unless you can provide me with some type of law that supports the notion that a unanimity instruction is necessary when there's two theories of liability.
Ms. Morris is working on that currently, so if we can move on and come back to that so we can make progress in other areas.
Thank you.
Before we leave that, I would cite People v. Hall, 60P 3rd, 728, 2002 Court of Appeals opinion that supports the conclusion that a unanimity instruction is not required in the context of a complicity instruction.
Say that again, please.
People v. Hall.
Yes.
60P 3rd, 728 supports the conclusion that a unanimity instruction is not needed in the context of a complicity instruction.
Thank you. Let's move on, and if there's any other case law that you want me to consider, I'll be glad to do so. All right, the next instruction is one that was objected to by the defense yesterday and requested by the prosecution. I think it's necessary. If not, it's the jury's being asked to do something without really an explanation. And this is I guess what I call a bridge instruction, or instruction that informs the jury why they're answering a question about domestic violence.
Your Honor, I apologize for interrupting, but I just noticed on page 2 of 2 of the previous instruction regarding complicity.
Yes.
At the very top, again, we need to remove the second of.
Understood it? Okay, thank you.
And then in the last 2 paragraphs, are we changing the language there to mimic what we changed earlier, which indicates the reference to count 2 instead of Heather Frank?
Sure, so we could say as it relates to count 2 in the complaint and information
Yes,
on both paragraphs.
yes.
You got that, Shira?
Yes.
Great, thank you.
Thank you. I'm sorry to interrupt.
No, you're fine. I appreciate the comments. So the next instruction explains to the jury that they're going to be making a determination if they find Mr. Eastman guilty as to the counts involving Ms. Frank. And the question is, was this an act of domestic violence? So I unbolted that at the request of Ms. Devereaux, even though she objects to the entire instruction. And then I defined domestic violence and intimate relationship. And the question on the verdict form will cross-reference this instruction.
Again, I strenuously object to this instruction. I went back all the way to Colgy 2019 last night, and in no way does 2019, 2020, 2021 have this type of instruction included. They have the definitions, but the definitions are just included with the rest of the definitions that are up in the different sections. So I think by separating the domestic violence and the intimate relationship, the court's putting undue emphasis on a very sensitive topic that invokes a lot of emotion, and I think is very prejudicial to Mr. Eastman. I don't see the need to highlight or emphasize the alleged acts of domestic violence when we wouldn't do that for any other definition. We're not doing that for persons. We're not doing that for any of the mens rea. We're not doing that for the after or for the definition that Mr. Wren requested.
That's because there's no other interrogatory that they're being asked to answer. And so to me, this is explaining to them why they're being asked to do something.
But I think that that's why we have the verdict forms the way we do and the interrogatory there. And so all this is supposed to do is help them get that information in terms of what the definition is and what that means. But this just overly emphasizes what domestic violence is. And I went back to Colgy in 2019 and 2020 and 2021, and they don't have any sort of instruction that highlights domestic violence.
Do you think that I understand your objection, do you think that the instruction itself is a correct statement of the law?
Yes.
Mr. Wren, anything you would like to say?
No, I'll stand on my previous record.
So the court's going to overrule the objection of the defense, and I'm going to give this instruction. The next instruction is, members of the jury, you may discuss this case only when. Any objection?
No.
No.
The next instruction deals with the integrity of the evidence. Any objection to this instruction?
I guess this is where we need to talk about logistics as to how the evidence is going to be made available to me.
Right. So it's, for the record, there's a lot of, the evidence takes up a lot of space. There's some physical evidence that's large. The jury room is going to be cramped if I put all the evidence in there. So what I suggest we do is put I can leave all the evidence out here, or put the photographs inside, leave only the large items, for example, in the courtroom, lock the courtroom so my staff and I won't utilize it at all, and the courtroom will simply be an extension of the jury deliberation room so that they can view any evidence that they want, however they want.
I don't object to that proposal. I would ask that the court put as many of the quote-unquote smaller items in the jury deliberation room as possible and only utilize the courtroom for the larger items that would not otherwise fit in the jury deliberation room.
Okay, and perhaps after closings today, we can decide what those items are going to be. And that way, when they come in the morning, everything will be laid out for them. And we can organize everything in the courtroom itself so they don't have to be searching for certain pieces of evidence that they're looking for. Is that okay?
Yes.
Okay. Is this instruction okay, though?
Yes.
Yes.
Okay. Next is jury questions. Any objection?
No.
No.
Next instruction is, once you begin your deliberations, if you have a question, any objection to that?
No.
Sorry, my computer froze. No.
Next instruction, which I redid at the party's request yesterday, is the bailiff will now escort you. And I've added that they will be provided with 6 verdict forms and 3 verdict question forms. The 3 question forms being, was this an act of domestic violence? Any objection to this instruction?
No, but I would just point out again how we have other means of instructing and explaining to the jury how they are to consider the domestic violence. And
Okay. Thank you. Your objection is noted.
We do need to eliminate the second of on page 2.
Thank you. So the court yesterday had an instruction that I'm not going to give. It's not stock, and it is a bit cumulative. The one that the prosecution was requesting that says the evidence in this case consists of, defense objected. I just don't really see the need for this necessarily. And so any further objection on that, Mr. Wren?
No.
Before we get to verdict forms, any other instructions that you would like me to give? Ms. Devereaux?
Your Honor, nothing more than what I've already submitted that's been denied.
Is there anything specific that you submitted that
The expert
well, that's right, there's a
part
lot.
one, right?
It's included in here, it's just yours added another paragraph. Anything else? Any additional instructions that are not included in these instructions?
No, nothing additional. The only thing is we would ask the court to modify. No, they have it that way. I'm just sorry, we're just double checking the verdict forms. Okay, it's been corrected. The very first 2 verdict forms.
But we haven't gotten to verdict forms yet. I'm just asking for instructions.
No, nothing further.
Mr. Wren, do you have any additional instructions you would like to offer?
No, Your Honor.
Okay. So I think unless I get any case law with regard to unanimity on different theories of liability, I think we're ready now to talk about verdict forms. And so the first verdict form deals with Mr. Sessions, murder in the first degree. Any objection to this instruction?
We would object to verdict form regarding count 1 and count 2. For some reason, only on those ones, the court has the guilty option listed first, and the remaining counts have the opposite.
That wasn't intentional. I just think I grabbed it from somebody.
And in addition, those are the only verdict forms where guilty or not guilty is bolded. The rest of the counts do not have it in bold.
Do you want not guilty first?
Yes, please.
Guilty second? I do think it's important to bold it so that way it stands out.
I don't have an objection to it being bolded if the remaining counts are also bolded. I just don't want it to be, okay, so.
Well, every option of guilty or not guilty will be bolded, but we'll make sure to put not guilty first and guilty second.
Yes, please.
Okay. You okay with that, Mr. Wren?
No objection to that change.
Okay, and then I have for count 2, for Ms. Frank, I have the question, yes, this was an act of domestic violence as defined in instruction number blank, and I'll fill that in, or no, this was not an act of domestic violence, and a location for the foreperson to sign.
I would just request the court flip that and have no first, which is consistent with having the not guilties.
Okay, that's fine. Count 3 and 4 deal with tampering with a deceased human body. And as it relates to Ms. Frank, we have the interrogatory and we'll flip and put no first and yes second for a designation of domestic violence. Any objection?
No.
Mr. Wren?
No.
And finally, tampering with physical evidence. Again, for Ms. Frank, we'll switch to make no first and yes second for the designation of domestic violence.
Thank you.
Any other corrections, modifications, objections, suggestions? to
No,
these
again, I just
instructions?
want to renew all of our objections under both the Colorado and United States constitutions.
Thank you. Mr. Wren?
No.
We're going to fill in the blanks for the instruction numbers. Does anybody have an objection as to the order in which these instructions are presented?
No.
No, not necessarily.
What does that mean? No?
No.
Okay.
Yeah, well, you're all right. I get,
You should
sorry.
ask us these.
I always have believed, and I know different judges do it different ways, but that well, actually, I withdraw that thought. I'm fine with the way they are.
Okay. I'm not sure if you were thinking about the theory of defense, but I thought the theory should always come after the charges. Is that what you were thinking?
No objection to
Okay. All right, so we'll fill in, I'm not sure if you want Mr. Eastman present. All I'm going to do at this point is fill in the blanks for the instruction numbers, send you a electronic copy that you can use possibly for your closings, and make copies for the jurors. Are we good?
Yes, Your Honor.
Do you want Mr. Eastman here for me to give you the final set with the numbers on it? Nothing's going to change.
He would like to go.
Meaning he doesn't want to be here right now.
Correct.
Okay, we'll number everything and get you copies, and the court will be available to you for setting up everything. And I'd like to get started at 12:45 with a couple of breaks this afternoon. We're probably going to, assuming that you use your entire 2 hours, I don't know if you will, maybe a few minutes after 5 o'clock today.
Does the court intend to have the jurors head home and start deliberating the following morning?
Yeah, yes, I'm not gonna, it's gonna be at least 5 o'clock, I'm guessing. And so, yes, I'm going to have them come back, and then we'll have everything laid out for them. Perhaps at some point we can talk about taking another inventory of the instructions to make sure that they're not getting things that were offered but not admitted, or referenced but not admitted.
You said instructions, do you mean exhibits?
I'm sorry, exhibits, yes. Maybe we can talk about it between now and 12:45. Maybe if you can come a little bit earlier, or if you want to do that tomorrow morning.
I think it probably makes sense to do it tomorrow morning.
Okay,
I agree.
okay. Maybe I'll just do an inventory and send it to you and Cheryl and make sure that we're all on the same page. How's that?
We would appreciate that, Judge. Thank you.
I'll do that sometime this morning. Okay, I think we're all set, and we'll work on getting you that final draft with the filled-in number for the instructions. Thank you.
Judge, one brief
ma'am.
question.
Yes.
Just in terms of where the location of the podium is, do you have a preference? I think it's kind of in an awkward position right now for closing. Are we able to move that a little bit and kind of center it and face the jury?
I'm okay with that. I'm being told that, I know it's been moved already, but I'm being told that there's wiring underneath the podium, so I'm just concerned that it's going to get, something's going to happen with the wiring, and I think you can move it a little bit. I'm concerned that it's going to mess up the wiring.
I know, and I think it's the county courts, they have those portable ones. Could we steal one for?
No.
I mean, steal I wasn't suggesting a crime, I was just, you're suggesting
You
borrowing.
can't borrow one, no.
Okay.
Everything is wired. I think you could probably turn it a little bit,
Good.
and you're not bound to be at the podium as long as everybody can hear you. Okay, and I do have a handheld mic if you wanted to use that during your closings.
I would say that, if people are going to be straying from the podium, I do think it's important to use the microphone, given that I think it's been difficult to hear anybody when they're not mic'd.
Okay, yeah.
What do you think about that, Mr. Wren?
I'm not gonna require that you be at the podium as long as you're near a microphone so we can hear you. If your style is that you wanna be away from the podium, I'm okay with that as long as the court reporter can hear you.
I guess I would not want to be required to use a microphone if I'm away from the podium as long as everybody can hear me. If I'm being told that people can't hear me when I'm away from the microphone, then I'll certainly be open to using the handheld.
Okay,
We don't mind.
okay. I think we're all set. We'll see you at 12:45 today to get started.
One last housekeeping courtroom question. Can we bring the plasma screen forward closer to the jury like
Yes.
we did with previous witnesses for purposes of PowerPoints?
Yes.
And then also I would like to use the easel, and just to give court and counsel notice, I would like to, or I'm requesting the opportunity to just put up a poster board that has the month of February of 2020 on it. It's just a calendar of the month of February. Most of those dates have already been stipulated to anyway.
Is the calendar filled in with
No.
dates?
It's just blank.
I'm assuming with the days of the week and the day of the month.
Correct.
Your Honor, I guess at this point, there's not been a calendar that's been admitted into evidence. I think certainly Mr. Wren can, create his own demonstrative evidence for closing, but I don't know that something printed like that is something that would be permissible. I think he could draw a calendar if he wanted to on the easel to use, but it's not evidence and not an exhibit that would go back with the jury.
Seems to me it's demonstrative, and I think through circumstantially, Mr. Wren can work backwards and forwards for the month of February of 2020 based on the court taking judicial notice of 2 other dates in February. Doesn't seem like it's prejudicial at all, and it's demonstrative. And I think based on an instruction that says on February 15th, this time of the week, circumstantially, he can work forwards and backwards from that calendar. So I just don't see how that is prejudicial. It's demonstrative, and so I'm not going to prohibit the prosecution from putting up a blank calendar from February of 2020. Anything else?
Can we, off the record, work on moving the podium in a careful manner to a place that everybody agrees on that's not going to damage the wiring?
Yeah, maybe I'll have my IT person come here to make sure that you're not messing it up.
Fair enough.
Fair.
I would note that it was moved earlier in the trial
It
to
was.
its current location for television purposes.
It was. I'll have, his name is Nathan, I'll have Nathan, if he's available, come and maybe he can assist to make sure nothing goes wrong.
And I think both parties are hoping that it would just be moved back closer to the box and turned in a direction that it faces the jury.
Okay.
Agreed.
Yeah, so other than the podium, the courtroom is at your disposal. You can arrange it any way that you want in order to make your presentations. Okay?
Thank you.
Thank
All
you.
right. I'm gonna see if Nathan's available, if he can come now, so he can. Currently he's not available, but we'll try to get him over here. Don't move the podium until you get permission. Thank you. Give us, I'll get you the electronic copy and the hard copy shortly. All right, we're off the record.
everybody out there in gardening land, and welcome to a special edition of the Row by Row Show. I know this is not how it normally looks. We're not on our normal set tonight. We've got a special guest with us. Greg's on vacation this week, and so he wasn't able to make the show. And I got my good buddy Jason at Cog Hill Farms to join us tonight. Doing this via Zoom meeting, so if the clarity is a little off or the audio is a little off, we do apologize in advance. This is done on Zoom, not on necessarily our big camera that we normally show them. But we're glad to have you with us tonight, and we got some really cool stuff to talk about. I'll let Jason talk to the crowd for a minute there before we get started.
Yeah, if you guys don't know who I am, YouTuber, farmer, gardener. We like to have a lot of fun from Central Alabama, and just happy Travis asked me to be a part of this. For real, this is just pretty awesome.
Yeah, so Jason and I have become good buddies over the last few years. I've actually been up to see his place, and we work together with our YouTube channels, but we also are just good friends and like to talk gardening and homesteading and just about everything else. If you've not seen Jason's channel, we'll put a link below to that. You can go check out the Cog Hill Farm channel, give them a good subscribe there. If you like animals on the homestead, he's the channel to watch. He has got every animal you could imagine. And
we got a lot of animals. A lot of animals.
So we were originally going to talk, before Greg hauled off, we were going to talk about cool season cover crops this week, and we'll put that on hold till next week. And we're going to be talking about some gardening techniques later. But before we do that, we always have our show and tell segment. And it is customary with the Row by Row show, Jason, that we always eat a little snack on the show. So what I've got right here are some Seminole pumpkin muffins. Or cupcakes.
Wow.
You might want to call them cupcakes. They're really good. So one of the girls in our seed room, her mom grew some of our Seminole pumpkins this year, and has got tons of them. She brought some of these. She actually even brought a little thing of icing. I didn't bring that home, but these things right here are absolutely delicious. I'm going to partake if you don't mind.
We've done pumpkin pies out of those Seminole pumpkins, and they are fantastic. Fantastic. Matter of fact, that's what we do mostly with our Seminole pumpkins in the past. We're strictly pumpkin pies.
They store so well.
Oh, God, they'll last forever.
I'm almost wondering if I could take some of those South Anna butternut squash I have, since they're, half bred with the Seminole pumpkin, and make some muffins out of them. I think the taste should be pretty similar on the butternut to the Seminole.
I bet you could.
So I don't know about up there where y'all are. So we're close to being in the same planting zone. Jason is a little bit north of us as far as the latitude goes. Down here, I just got my stuff started in the greenhouse, my fall transplants. Got those going. Just working on kind of getting some of these garden plots cleaned up and ready for some fall planting, some onions, elephant garlic. Speaking of elephant garlic, we got that in, folks. It's going fast. Like, I'm talking really, really fast. So if you want elephant garlic or shallots, you need to get it now, because it looks like we are going to run out. We can get another shipment, but it's not guaranteed, and the quantity that we can get on another shipment is not guaranteed. So if you want those, you need to get those. They've been going really fast. I think Jason's got some. He's going to be planting pretty soon.
Yeah, I got them this week. I've also started my transplants. Broccoli, all my leaf vegetables, collard greens, which I'm excited about. The new collard greens that you got in this year.
The top.
Got those going. Matter of fact, I started mine last week, and they're already. I tell you what, I just looked at them tonight, and I got roots coming out the bottom of the seed trays already in probably a week and a half.
That's awesome. That's awesome.
Crazy.
We did a show several weeks ago on seed starting techniques, and it's one of those things a lot of people struggle with. But once you get the hang of it, man, it's so rewarding. And you've got a lot of great videos out there on how to do it inside. when you don't have a greenhouse.
Do it. Yep.
So, if you want to see how Jason grows transplants in our big trays inside and does really well with them, you can see those videos of his channels. But it can be done, and seed starting
Can be done.
You being the testament to that. Once you get the hang of it, man, it's like riding a bicycle.
It really is. It really, really is. It's the only thing I've struggled with is peppers, but other than that, it's been pretty easy.
Yeah. So we got our transplants going. Onions, got onions going. I think you're growing some of the cougar onions.
I'm growing some of the cougar onions. I don't know if you saw my Instagram post today. Growing some of the cougar onions. Super excited about the onions. This will be my first time growing onions by seed. I've always done it. Probably like a lot of people go to the feed store and they got the little plants or slips or whatever you want to call them,
right,
and wrapped around a rubber band, and you grab them and you throw them in the ground. And I haven't been successful at all growing them that way.
Yeah, girl. We did a little testing last year, and we've always grown from plants too. But we started doing our own seed, and the results were pretty remarkable comparing the two there. Onions are pretty hardy, but that time out of the ground is pretty valuable. And if you can keep that from happening and go straight from the trays to the ground,
I can imagine
like a healthier plant of the bigger onion. So I'm not really harvesting a whole lot in my garden. I got a few peppers left. I have been digging these bad boys. So these are our Georgia Jet sweet potatoes. And I picked out a few of the best ones. These what around here we call number ones. And I got about 5 rows of them. And we've been trying to, me and the wife and kids, get out there and knock out about 1 row a day. It's you don't want to take on all of it at one time, but get out there and knock out 1 row a day. I still got those purple sweet potatoes. I haven't mowed those down and got ready to dig those. Those ones Wes sent me. I'm really excited. Everybody says they taste so good. I've never grown them before.